Joe DiGenova joins us right now, as he often does Monday mornings at this time when we're lucky. Legal analyst, of course, and former U.S. Attorney of the District of Columbia. All right, Joe. We saw lots go down last week with regard to the Supreme Court. Let's start with the same-sex marriage ruling. I've seen a lot of my conservatarian friends, as we like to call ourselves, conservatives with a very strong libertarian streak, saying amongst ourselves, all right, we're happy for the outcome here. We're happy for our friends who wanted this to happen, but we're not happy with the way the Supreme Court got there and the fact that this is such a sweeping 50-state decision. Is that an appropriate response? Is that hitting the nail on the head?
I think they have it exactly right. As you know from our prior discussions on this, Larry, my view was that the court should have allowed the states to adopt their legislation. If they wanted to have same-sex marriage, that would have been fine. For those states that didn't want to do it, they would nonetheless be required under the full faith and credit clause to recognize gay marriages from other states. Instead, the court stepped in, created a constitutional right under the Equal Protection Clause. Terrible mistake. This is Roe v. Wade redux. This is the same mistake. They interfered in a political process that was actually going the way of the victors. And by doing so, they stripped away one of the most important parts of the American Constitution, which is the experimentation with federalism in the states. Here we had a solution already on its way. Mm-hmm. States were adopting pro-gay marriage legislation. The people were speaking. Some states, they weren't doing it. It was exactly the way the founders intended our democracy and our republic to work. And once again, the Supreme Court clumsily interfered, just like it did in abortion in 1972 or 74 in Roe v. Wade, when then abortion was on its way to becoming legal in almost every state. This is a self-inflicted wound. It's going to lower, in many people's eyes, the importance of the court. But, you know, that they decided to do it. Justice Kennedy was just real happy with himself.
But Joe, you mentioned yourself right now. I mean, that this is something that do we have like basically judges gone wild, robes gone rogue? I mean, right now, does it seem like the Supreme Court has so much power compared to maybe courts in the past? Well, because they do. They do have real power. You know, there's an old saying, the Constitution means what the Supreme Court says it means at any given moment. This is an example of a court that has lost its way in many ways. The best, but really the better example of the court losing its way is the Obamacare case.
Yeah, well, let's turn to that one, because I know that we talked about this quite a bit over the last several weeks, and you must have been surprised when you saw Roberts contort himself in a way on this one.
No, actually, as you know, I predicted that they were going to rule this way, and that Roberts would contort himself once again. This is an example of Roberts caving in to the intimidation of the President of the United States.
Again.
As I've said before, this started in January of 2010 when the President gave his State of the Union and attacked the Supreme Court to their face in the chamber, in the well of the House of Representatives over Citizens United. He conducted a campaign to intimidate the court. He got Roberts. He intimidated Roberts. He got Roberts to think about his legacy. And so Roberts caved on Obamacare. Disgraceful conduct by the Chief Justice and embarrassment when you read his decision in the Obamacare case, and then you read his dissent in the same-sex marriage case. You have to be someone who has two personalities to be able to live with yourself by writing the things that he writes in those two opinions. It's quite remarkable. He's schizophrenic.
Well, then, do you agree then with Senator Ted Cruz? I mean, you're a man of the law. You've done a great job of studying it.
I'm a man of the law.
Do you think, you respect it. Do you think that it's time that we invoke term limits on these Supreme Court justices, or could that have a long-term nasty effect on what the whole purpose of having the Supreme Court is?
Well, I don't believe there should be term limits on the Supreme Court. I believe in life-term appointments for federal judges. I think it was in the Constitution. I think our founding fathers and mothers did the right thing. I do think that you have to be careful about who you choose. Sometimes you choose wisely, sometimes you don't, and sometimes you never know what you're going to get. It's like a box of chocolates. And the truth is, you know, the system works well. I'm not happy with these two cases because I think they were decided in the wrong method, not necessarily.
Right.
And I would have done it differently. And I think the real villain here is Chief Justice Roberts. He has done profound damage not only to himself, because he's the laughing stock in the Federalist Society and in conservative legal services because of it's so obvious that he caved into the president. The court we'll survive, we will survive. But this now means that it's really important to elect a Republican president in 2016 because there are going to be at least 2 vacancies, and that will be the court for the next 50 years. So if Republicans care about this, they better get their act together, and we better win this election. Because if we don't, the Supreme Court is going to look like a very different place in 5 years.
Joe DiGenova, one last follow-up on this, and then we do want to talk to you about the Freddie Gray case, which a lot of news was made over the last several days there. Is based on the logic and argument used in this same-sex marriage ruling, the equal protection and the due process, can a gun owner who has a concealed carry permit in one state, which has reciprocity in 33 other states, should they now believe that they now have a 50-state right for their concealed carry based on the equal protection and due process ruling?
Well, they haven't made that argument yet in the Supreme Court, but I assume that they will. Because, remember, we're talking about a constitutional right here. That's in the Second Amendment.
That's actually in the Constitution.
I said it's a constitutional right. It's the Second Amendment. The Supreme Court has ruled that you can have a gun in your home. Now, the Supreme Court has not specifically ruled on the constitutionality of concealed carry, but it's coming. And believe me, what the same-sex marriage case does is when you have a constitution, this is even a stronger case, the Second Amendment, because it's in the Constitution.
Right, compared to
gay
the
marriage is not in the Constitution.
Or for that matter, any kind of marriage reference.
I mean, it is absolutely, but I can tell you that this court, given its makeup, will contort itself to make sure that that concealed carry cannot be interpreted that way. This is going. Let me just tell you, there's a prairie fire out there over all kinds of things. If the court is not careful, they are going to find themselves like they did in the 1950s when Impeach Earl Warren signs were up all over the country. Roberts is one step away from where John Koskinen, the IRS commissioner, finds himself right now, impeachment. I wouldn't impeach Roberts. I'd let him stew in his own juices. But believe me, there are a lot of people out there who really want him gone.
Well, talking about wanting gone, this gives a great transition to the mayor of Baltimore. More importantly right now, the Attorney General, the state's attorney, Marilyn Mosby, wanting her gone because a lot of people think that she hasn't handled this case in Baltimore, and she is more concerned with her fashion magazine interviews and those deadlines than necessarily the law at hand. You know, we had a couple of filings happened on Friday with those involving Freddie Gray. Let's, where do we stand with that and going forward? Do you think we actually have a case of giving these police officers a fair trial in Baltimore, and are they going to be going to jail in the end?
Well, we're a long way from any of these officers going to jail. I think what she did Friday was she filed a couple of things. She filed a motion to sever the case of 2 of the officers, Lieutenant Wright and Officer Porter, from the other 4. That's interesting because what it shows is she's now decided that her case doesn't work well. Now, what does that mean? It means she indicted too soon. This was always too quick an indictment. She did not conduct a thorough investigation. With regard to venue, the police officers have asked that the trial be moved out of Baltimore, perfectly legitimate request given the circumstances, and particularly given the conduct of the state attorney herself, who held several press conferences, which are nothing if not some of the most prejudicial comments ever made by a prosecutor in any case. Her conduct in this case from the beginning has been remarkably unprofessional. She is clearly not a seasoned prosecutor. She doesn't even understand her role. Some of her public comments have been absolutely disgraceful as a prosecutor. They would be actionable if the bar in Baltimore had its senses on and were alive and alert. If I were a judge, I would move this case to Cumberland, Maryland, or the Eastern Shore. There's no way these officers are going to get a fair trial. And in her motion, she says that the defendants don't understand how you pick a jury. They understand all too well how you pick a jury when you have a prosecutor who makes the kind of prejudicial comment she has made about the absolute guilt of these officers. I mean, her conduct is absolutely disgraceful.
I don't know, Judge, we got to leave it there, but it sounds to me like you're making a case for her to get a presidential appointment from Barack Obama. She's perfect.
She's ready. She's Obama heavy.
She'll be on the
Obama
Supreme
light.
Court. Yeah. All right.
Yeah.
Thank you, Joe.
Send her up.